It seems like a lifetime ago, back on October 9th when we started to select this jury. And back then we asked a bunch of questions. And the most important of which was whether or not you could set aside your feelings and your emotions and be a fair and impartial juror, to which all of you said you could. The reason why I bring that up now is because of something the state just said about the burden of proof. The burden of proof is the requirement. The state has to overcome the burden of proof. Okay, they hate it. They have complete and utter disdain for it, which is why Mr. Dean used the term wrapped around the axle. As if you hold the state to their burden of proof that there's something wrong with you, that you're not normal or straight, or somehow you're getting twisted, that's not really how our system of government and our court systems work. We selected you, and you are the perfect jurors for this case. We're not asking you to set aside your life experiences. We're not asking you to set aside your feelings or anything like that. You were selected for who you are and your unique experiences by both me and the state of Georgia. In that regard, you are the perfect jury to consider this case. Now, and I say that, and during the course of this, there is nothing personal between Mr. Dean or Ms. Parker or myself or Mr. Purse or Ms. Lemons or any of the witnesses. But it's an adversarial system, okay? I am their adversary. It is my job to stand up and defend my client, Ms. Simon's, rights. And it is my job to hold the state to their burden of proof. I don't take that task lightly. And it's been my job to do that since we began. Now, what happens next is I take that responsibility and I turn it over to you. And I'm going to start with my biggest fear. And my biggest fear is this case deals with so much emotion. It has from the beginning. I don't think that's an overstatement or an understatement. And I know there were times during the course of this trial where every single one of us felt something deep down inside of us. On more than one occasion, we've seen witnesses break down, seen jurors break down. It's a serious matter. But the law gives us guidance on what we're supposed to do when that happens. When it comes to emotion, the law says that the case must not be side-decided, for or against anyone because you feel sorry for anyone or you're angry at anyone. Your verdict is to be based on evidence. It's not to be based on emotion. And in times during the course of this trial, the emotion was directly pointed at you. How could it be otherwise? And I think that it's important for all of us to acknowledge that. There were things that were done to draw your emotion up, to play upon your emotions, to manipulate and twist your emotions. Things to get you angry, things to get you upset, things to dehumanize Miss Simon. Things to get you to make judgments about her that have nothing to do with the evidence in the case. Now, I wasn't the one doing this, but these things were done. And to pretend that they were not is just not accurate. You heard a lot from witnesses. And I'm going to talk about, there's basically 4 types of witnesses, and I like to identify them because it's up to you to determine, just like Mr. Dean said, the manner and method of testifying, what type of witnesses they are. As a defense lawyer, I basically put them down into 4 different types. Number 1 is a police witness. Police witness can be unbiased or biased. It basically depends. I mean, to be quite fair, a police witness is paid government money to investigate and prosecute crimes. Some of them think they have to put their fingers on the scales, other ones don't, but they're police witnesses. That's kind of one of the first categories I put them in. The second one is the civilian witness. Of course, that's an easy one. Denard Johnson, Ways Pro, those guys. They're just a civilian witness that get called into the investigation. Paul Simon, one of my personal favorite, a civilian witness. Miss Bowling, civilian witness. Then there's what I call like a fact witness, someone that you would normally never hear from, but they just have some sort of fact to give. They can be civilian or they can be police. In this particular case, I would say any of the forensic examiners kind of fall in that category. And the final one is what I basically would call a sock puppet. A sock puppet witness is somebody, and it's usually a police investigator or someone like that, who basically gets up and wants to parrot what the state's theory is. Now, in this particular case, emotions were very high. I don't think that's an extravagant statement. And a lot of the witnesses are going to say, well, this didn't conform to normal, or this wasn't right, or basically, she reacted differently. That's not what the law calls for. The law calls for you to base your verdict on evidence. Okay? And the reason it's my biggest fear you're going to base it on emotion or something that's not completely or at all relevant to the issue is it's difficult to push these feelings aside. It's difficult to put this prejudice aside. And it's difficult to look at evidence, especially in a case dealing with a dead 20-month-old. I cannot think of a harder case to do it in. Now, Quentin Simon was a sweet, innocent child. I don't think anyone said anything different. He died far too young. I don't think anyone said anything different. And if I have, to any extent that you've maybe thought that that's where I was going with that, I apologize. I never, ever, ever meant to come across that way, and I don't think that I have. There's no doubt about these two things, and no one in here disputes it. But to parade witnesses up here, witness after witness, basically they're going to testify, that testify for the state, and to make this argument that in some way, shape, or form, who Miss Simon was having sexual affairs with was in any way, shape, or form relevant to the question of how Quentin Simon died is just horrendous. It's meant to evoke an emotional response from you. We said in the beginning that most, if not all, of the state's case was based upon speculation and character assassination. I believe those are the exact words Mr. Peirce used. And we sat here for an hour and 28 minutes and listened to Mr. Dean say exactly that. Now, this was their strategy from the beginning. They can pretend that they did something, and I'm not saying that the task was Herculean, obviously, to search the landfill. I learned more about landfills than I've ever wanted to know in this case. But the state made a misstatement in its closing. I asked Mr. Johnson on cross. There were 1,500 loads of trash in that landfill from all over Chatham County and surrounding counties. They pretend like there wasn't other places this could have come from. And the reason why is because they have to. I asked Mr. Youngkin a lot of questions. Mr. Youngkin, quite frankly, the state has to believe Mr. Youngkin's testimony. Their whole theory of the case depends on it. Because of Mr. Youngkin's statement that he saw Quentin Simon at 3 a.m., saw Quentin Simon at 5:30 a.m., and then texted the babysitter and Quentin was fine, their entire theory of the case falls apart. They have to believe Mr. Youngkin. Mr. Youngkin is the best example of a sock puppet witness we have. He had every reason to get up there and say exactly what they wanted him to say. And we heard very early on, he told them that he was trying to save his own butt. And that's fine. I get it. He went so far as to wire a hotel room with video and audio and to tap his own phone to try and incriminate Ms. Simon for the police. Okay? That's Mr. Youngkin. Now, the state's strategy and the way it's presented its case has been basically to tell you, and I don't think I'm stating anything out of place here, that Miss Simon was a slut, a party girl, someone who lies, a horrible mother, someone who didn't act appropriately as a mother. All of these things could be true more or less to some extent, but none of these things have anything to do with the central question in this case. And they still haven't answered that question with evidence, not speculation, okay? The central question in this case is how did Quentin Simon die? Where did Quentin Simon die? And in what manner did Quentin Simon die? They've charged Miss Simon with murder. Okay, that's a hell of a thing. And it's supposed to be a tall order. So I'm sorry if the burden of proof seems a little lax or inconvenient to the state, but in this particular case, they made the allegations. And here's the thing. Mr. Dean was explaining this because they really don't have any idea about any of these things. They just have their best guess. The state whole evidence with regard to counts 1, 2, and 3 comes down to their wild ass guess. That's it. Because any part of their theory and speculation that changes, it falls apart. Mr. Dean was talking about the door opening and closing. Well, he played the video for you. The first video was she said that the front door was unlocked. Okay? He spent this entire trial saying it was open. That wasn't what she said. But, okay, whatever. I understand that you have to say that and you have to see it that way because your entire theory falls on that. But let's just assume for a minute that, okay, so she said it was unlocked and it was shut. Well, the back door was opening and closing all night long. Okay? Now, Danny Youngkin said he went to sleep. He has to believe that Danny Youngkin was asleep. His case depends on that. Why? You've seen the layout of the room. Okay? You saw the racing bed where one child slept. You saw the pack and play where Clinton slept, and you saw where the baby slept, and then you saw where Danny and Leilani slept. It was one room, wide open. They have to have Danny asleep, and they have to have their exact timeline, because to do otherwise destroys it. What happens if Danny's testimony was correct? It doesn't fit their timeline. So of course they had to go in with Danny Youngkin from the beginning. Now, they didn't come right out of the gate and show you any evidence of time, manner, method of death or anything like that because they don't have it and they're never going to have it. Now, they're asking you to use your emotion to get angry and to convict based upon that. And that's simply not proper. Now, we're at the end of a journey here that's been 2 years in the making. And the key question here is, how did Quentin die? That's why we're all here. That's really it. Was it an accident? Was it a murder? What was it? Especially as it relates to the aggravated assault, the cruelty to children, and the murder charges in the indictment. What happened to him? What is proven beyond and to the exclusion of every other reasonable doubt? Not just some, but every single one. That's the burden of proof, and they've never answered those questions. In fact, there was a great deal of things you were probably looking for and never really got. for most of this, they were trying to say that October 4th was going out to 204 to see Craig. That didn't materialize. They had the text messages, which you can look at. And the thing is, I don't really understand how any relationship with Craig does anything to shed any light on how Quentin died. Unless you believe the fevered dream they've come up with, that in some way, shape, or form, this has something to do with her attention seeking. And I don't get that, because if someone is craving that much attention, and they find that attention, and they have someone that gives them that attention, wouldn't that take away the struggle? Wouldn't that take away the strain? I don't buy that. Now, as regards to counts 1, 2, and 3, let's talk about, Mr. Dean did talk about this a little bit. Accident. I don't know whether an accident happened or not. It's as good a theory as any. We do know there was vomit. We do know there was an overwhelming smell of vomit. We saw Sergeant Stewart, one of the first officers to respond, refused to go in the house on his body-worn camera when Lemons went in because of the smell of vomit. This man was a 35-year-old detective. I mean, a 35-year-old police officer. He's been on the force for 35 years. Okay? He noted that. Lemons noted that. But you know who didn't know that? Danny Youngkin. Nowhere at any point in time did he ever note that. Now, I'm not saying that Danny did anything wrong. My theory is that indicates some sort of accident, some sort of suffocation, something. I don't know. But the difference is I don't have a fixed interest in the outcome there. They do, which is why they have to build this mountain out of a molehill. They don't have that evidence. They never will have that evidence. They have to depend on Danny Youngkin. Because if anything changes, if he was up at 3 a.m., he said to feed Sky, and Quentin was fine. Never explained that one. If Quentin's fine at 3 a.m., like Danny Youngkin said, their favorite witness, then the 1 o'clock Azalea trip doesn't matter, does it? They have to believe that. They have to peddle that. They have to sell that. They have to say he was mistaken or wasn't lying, which is always interesting to me. Now, I would love to solve the case. I really would. But I don't have to. They do. I have just as many wild theories as they do. Everybody does. But I don't have to prove them. And more importantly, and this is the most important thing about that, I can have as many wild theories and stand here and tell you those theories as they do. Okay? But it doesn't change the burden of proof. It's just wild speculation, not unlike anything they've done. It doesn't change that the burden of proof lay with them. And the fact is, and they don't like to talk about this, or maybe they do, maybe they're trying to gloss over it. With regards to counts 1, 2, and 3, they have not come close to meeting their burden of proof. The time, manner, method of death. Yeah, that's not part of the requirements, but you have to show that it happened that way. There's no evidence that it was a homicide. There's no evidence that it was murder. None. Zero. Zilch. There never will be. And that's the thing they can't talk about. Because to talk about it and to give voice to it undermines their case. But you don't have to believe me. They don't know what happened. Their indictment says they don't know what happened. The state had to concede that in their closing argument, that they don't know what happened. You cannot speculate someone into a guilty verdict, ladies and gentlemen. And Mr. Dean used an example, and I like this example. It's actually a pretty good example, and it cuts both ways. He was talking about, I'll use a different example just to kind of differentiate. Circumstantial evidence. Okay, circumstantial evidence. The example we normally give in Georgia is If you're sitting in here and you walk outside and you look around, and when you walked in, the ground was dry, and you walk out, the ground is wet, then you can infer it rained, right? Makes sense. But what you can't do is walk out, see a wet ground, and infer that it's snowing in Denver. Those aren't the same things. So speculation is speculation. Inference is inference. There was no evidence. I asked Dr. Darasol if having the vomit would have made a difference in what she could and couldn't do, and she said yes. I don't control that. They do. You heard from the young lady from the forensic toxicology lab that she didn't have enough to test the vomit. Now, why would that matter? If it was a normal, literally, if it was just normal vomit, you would need to know that. He could have choked on normal vomit. If it was toxic vomit from getting some sort of poison or some sort of drugs, you'd need to know that. You would think. Okay? We don't. At least she said there wasn't enough to test, and I have no reason to doubt her. But that's a lack of evidence. It doesn't cut either way. And here's the thing, ladies and gentlemen, about the burden of proof and circumstantial evidence. When there's a tie in the evidence like that, the tie goes to the defendant every single time. It doesn't go to the state, it goes to the defendant. Now, when I was in law school, I had a professor who liked to tell this story to illustrate an example. Father takes his son to the restaurant. They're sitting in the restaurant. He says, "Here, son, draw a picture of a horse." So he draws a head, a neck, a back, 4 legs, and a tail. It's like, "How many legs does that horse have, son?" He goes, 4. He goes, "Now, what if the tail's a leg?" He goes, "Well, 5. He goes, "No, son. That's not how that works. The horse only has 4 legs. It doesn't have 5 just because I tell you that the tail is a leg. The tail is still a leg." So I can stand here and tell you stuff all day long. It doesn't make it true. Why do I say that? Well, the judge will charge you on this as well. The questions from the lawyers are not evidence. And I have to point that out in this case because there were a lot of very long-winded questions from the state. But that's not evidence. What comes from the witness stand and the exhibits is evidence. Now, why do I point that out? Daniel Youngkin was overlooked from the beginning. He started cooperating with them from the beginning. Okay? They literally did not look at him for anything. He made some statements to them which either, if they were true, blew up their timeline, and if they were not, were a lie and questioned his credibility. So they have a vested interest in believing him. So let's talk about him leaving. The question for you to determine is do you believe Danny Youngkin when he said that Quentin was alive at 3 a.m. when he got up to check on Sky? If you do, that blows up their case. Do you believe Danny Youngkin when he said he woke up at 5:30 or 5 o'clock to get ready to go to work, and then Quentin was fine, and then texted the babysitter that the kids were going to stay home? If you do, it blows up their timeline. Do you believe his statements from the witness stand that was all bull? That he was fed up with her? And whatever excuse he gave from the witness stand, quite frankly. Because if you do, then it means he was lying before. Now, I'm going to ask you to think about one of the witnesses who did testify, Paul Simon. He was personally one of my favorite witnesses. But he testified exactly different than what Mr. Dean wants you to believe. He knew Danny. And he testified from the witness stand that on that day, in that yard, when they were talking to the police, Danny seemed unfazed. He didn't seem upset. He seemed unfazed by this. Now, does that mean I think that Danny did anything wrong? Not necessarily. My theory can work the same way as their theory can. Danny woke up at 5, saw something that happened to Quentin, freaked out, threw him in the trash on the way to work, came home. He doesn't know anything. Does it mean he did anything wrong? No, I don't think Danny or Miss Simon harmed Quentin in any way, shape, or form. The evidence doesn't show that. I don't have any reason to speculate that. I don't have any vested interest in that particular outcome. They do. But it's in their best interest to believe that. It's in their best interest, when I say them, I mean the state, to try and sell that and peddle that. I asked Danny why he stayed here. Paul was so funny. He's like, man, this is what you signed up for. If you don't like it, because he said Danny was complaining when he got home. They forgot that part. Okay, they didn't want to mention that part because it shows Danny was unhappy. It's like, man, you signed up for this. If you don't like it, leave. I asked him why he didn't leave. And remember what he said? I wanted my daughter. Well, you know what? Between October 5th and October 9th or 12th or whatever the hell it was that he left Savannah, he didn't get his daughter because I asked him that question too. So the whole reason he stayed didn't matter when he left. And that didn't seem to faze them at all. But it's something you've got to question. Ladies and gentlemen, emotional decisions are almost always bad decisions. Okay? You have facts on your side, argue the facts. You have the law on your side, you argue the law. And whenever you don't have either on your side, at least with regards to the first 3 counts of this indictment, you depend on emotion. And that's what they've done. I don't mean to come across sounding harsh or cynical or pessimistic. And I don't mean to imply that the feelings that you and the officers and the search team and probably millions of other people have felt about Quentin Simon are not real. They are. I just mean to point out that they're not evidence. And that's what we're here for. They have to prove through evidence. Now, you're going to have to go back into the deliberation room. You're going to have to look at the actual evidence. And you're going to have to look at the actual law. And you're going to have to come up with common sense and use your judgment and leave the emotion at the door. It's a court of law. It's about cold, hard facts. Not emotions, not feelings, not speculations. Not mine, not theirs. I can't speak for you, but I've made emotional decisions in my life, and I can tell you to about a 99% accuracy that most of those emotional decisions were wrong. Not all of them, just most of them. So, you're going to have to go back there, and you're going to have to deliberate on each and every count of this indictment. And you're going to have to make decisions about each and every witness that testified. And then you're going to have to come up with a verdict. Now, the reason why I say that is there is another alternative solution. I'm not surprised when a 21 and 28-year-old couple who have a child together, who are doing drugs together, who lie about doing drugs together. Doesn't surprise me. It also doesn't have an inference of committing murder. Okay? That's what we're here for. That is the elephant in the room. The state does not like to talk about Danny. Danny was just as much involved in the drugs as Miss Simon was. Involuntary intoxication is not a defense. We're not even saying that. Okay? What I am saying is it's just not very honest to say they weren't doing drugs. And Danny said he wasn't responsible, but that was in response to, I mean, I'm sorry. You're in a room full of small minor children doing drugs that are toxic to those children. Is there any manner or method in which doing those drugs in that room can be deemed responsible? But he went out of his way to put, it was on top of a chest of drawers they couldn't reach. Anyone who's had children knows, and you don't have to leave your common sense at the door for this. Children get into everything. Okay? They do. They get out of everything. They get into everything. That is just what they do. And in Danny's own words, these were some mean-ass kids. And I suspect that no matter how responsible you were, they could get into something. Is that what happened here? I don't know. But neither do they. Now I'm going to talk about the concealing the death and the Azalea mobile home. To Mr. Dean, one of the things my dad told me was when you're a hammer, every problem looks like a nail. Okay? But a lack of evidence is still a lack of evidence. His timeline only works. And I don't understand. He's right. Motive's not an element of crime. But his timeline only works if it happens exactly the way he said it did. And in order to believe that, you have to believe Danny Youngkin. You have to believe that he, on his own, without prompting, without any prompting by anyone, said that at 3 o'clock Quentin was fine, and 5:30 Quentin was fine when he left, and texted the babysitter on his own without ever checking on one of those two things. But, see, here's the thing. He was being questioned by the police. You don't have to be a rocket scientist to figure out if they're questioning you and pushing you that it's probably not a good thing. They've never asked for a reasonable explanation of that because it would screw up their timeline. What if he was the 1 a.m. trip? That would screw up their timeline too. What if he wasn't? That would screw up their timeline too. Especially if he said that she was fine at 3 o'clock. So, now, that being said, Ms. Simon doesn't have to prove herself innocent of these charges. The state has to prove her guilty. And Mr. Dean said, well, we've done that, so you don't have to consider that. No. That's not how this works. Okay? You have to consider all of the evidence, all of the witnesses, all of the testimony. Not consider what I'm saying or his theory. You have to consider what you come up with. And with that, I'm going to get to what the burden of proof is. And how you the judge is going to give you the law. And I'm going to tell you if there's any conflict between anything I say or anything Mr. Dean says, the judge is the ultimate arbiter of this. And give me 1 second. I think I misplaced what I was looking for. So, count 1 is malice murder. In order to be malice murder, there has to be malice aforethought. Ms. Simon had to unlawfully cause the death of Quentin Simon, a human being. If you believe beyond a reasonable doubt that the state has proven that she did that, the only verdict you can return is a guilty verdict. But if you think there's no trace of that evidence whatsoever, your verdict has to be not guilty. If there's any evidence at all, even the smallest measure amount of evidence, a scintilla of evidence, your verdict has to be not guilty. That's not beyond a reasonable doubt. If you think that there's reasonable suspicion to think she may have did it, the only verdict you can return is not guilty. Because it has to be beyond a reasonable doubt. If you think that the greater weight of the evidence is in the state's favor versus the defendant's favor, slightly, that's what we call a preponderance, then your only verdict you can return is not guilty, because the standard is beyond a reasonable doubt. If you have a firm belief that everything that Mr. Dean and the state is putting forth is true, but you have a reasonable doubt as to what actually happened, for which you can state a reason, as a fair, impartial juror. The only verdict you can return then is not guilty. The only way you can get to guilty is if you're convinced beyond a reasonable doubt. That's a high burden of proof. And I present to you, ladies and gentlemen, as to count one, there is no way to get there. As to count two, and I'm being specific on this, yeah, they don't have to tell you what the offensive weapon was, but they have to prove beyond a reasonable doubt that it happened the way they said. There's zero evidence of that. Count three. Count three is the count that has to do with cruelty to a child, I believe. Now, their theory is that Miss Simon went into a room with two other sleeping children and Mr. Youngkin and did something to Quentin Simon without anyone hearing it or waking up, and then left to dump his body. Despite the evidence that Daniel Youngkin said he was fine at 3. Despite the evidence that Daniel Youngkin said he was fine at 5:30. Despite the evidence that he's the one that texted the babysitter. So let's turn to the concealing a death count. Again, the standard of burden of proof is the same for all of these counts. So I'm not going to be repetitive and do it for each one because I don't get paid by the word. So there's no reason. You can understand and assume that the standard stays the same. Concealing the death of another. The only way that count is proven beyond a reasonable doubt is if you believe that Quentin Simon's body was in the bag and she threw the bag in the trash at the Azalea Mobile Home Park at 1-something in the morning. Beyond a reasonable doubt. There's not evidence beyond a reasonable doubt. There's evidence she said she went. They have a theory. Hell, my theory is the same. She might have went to get dope. That's what I would guess. Cokeheads do cocaine. Opiate users do opiates. Weed smokers smoke weed. Okay? You have the text messages, and you have Mr. Youngkin's testimony. Mr. Youngkin told you that they were using every day at this point. Okay? So you have the statement that Leilani was trying to cover for Daniel. Their theory is that was a lie. But Daniel's the one that left town a few days after this happened. They don't seem to have any questions about that. That's always seemed odd to me. As a detective, going to detect stuff, walking into a scene where a child's abducted, my first instinct would be the non-related boyfriend or husband of the mother. But that doesn't seem to be the case here because it doesn't fit the timeline. That doesn't mean that I think Danny necessarily did anything wrong to Clinton. No. But it seems like a natural, obvious question to ask. It seems like a natural, obvious investigation to make. And it does look suspect that, A, he helped out almost immediately. He turned on her almost immediately. He set up the hotel video and audio surveillance almost immediately. Wiretapped for 60 days. Now they talk about that and they play these little excerpts from the statements, but the consistency from Miss Simon has been the entire time that she never harmed Quentin. And she didn't dump his body. So it is a hell of a thing, but if you're going to accuse somebody of a hell of a crime, you better have a hell of a good amount of evidence. That might start with actually proving that a murder occurred versus an accident. We don't have that here. So, ladies and gentlemen of the jury, you've been sitting here for 8 days of evidence and almost a half day of argument at this point. So I'm going to ask you, when you go back, and I'm going to tell you, just straight up, I don't give a damn about lying about smoking weed. I really don't. Okay? Most drug users lie about their drug use, Mr. Youngkin included. That doesn't usually concern me. But I'm going to ask you to go back and return the only verdict you can on this evidence. As to count 1, I'm going to ask you to return a not guilty verdict. As to count 2, I'm going to ask the same. As to count 3, I'm going to ask the same. As to count 4, there's some question as to whether or not A, this happened the way they say, B, who it was, and C, whether or not this even happened the way they're alleging here. That's reasonable doubt. The false report of a crime, I haven't touched on this very much, but you know what? The reality of it is that could have happened too. And it actually would make a hell of a lot more sense. And here's why. Rather than trying to say Miss Simon wasn't reacting, and I don't really know what the hell this means, but Miss Simon's not reacting the way you would expect someone to. Well, I'm fairly certain I don't react the way people expect me to sometimes, and you probably don't react the way people expect you to sometimes. But when it comes to your child missing or presumed dead, that tends to make people react in a weird way. So I don't think they've proven false report of a crime. If you woke up and your child wasn't there, what are you supposed to do? And she did report it. Okay? They tried to say in the beginning that she didn't, but you actually heard the 911 call was made from her phone, and Danny was the one that got on and talked because she couldn't speak. We heard the 911 tape. I didn't play it. They did. Making a false statement. The October 4th was to pay an existing drug debt. We saw the Cash App. We had no evidence to refute that or rebut that. Okay? So, could have been an existing drug debt, could have been new drugs. I don't know. But I think there's some reasonable doubt on that one as well. You saw and to be quite frankly, I don't really care about this one, but you saw her say, I only smoke marijuana. I don't care. I just don't care. Okay? Count 8, falsely stating the only controlled substance she had used in the past 24 hours was marijuana. Again, I just don't care. I really don't. And to be honest with you, it's an abduction case and it's a murder case. They don't either. Count 9, the Oragel statement. The Oragel statement's bothersome. But I will ask you this, and it's not to make an excuse, but they're pushing you for an explanation, and you give one. And even if that was the reason why you went and it didn't work out that way, is there really any evidence one way or the other? She says she went to see Misty. Does it matter if her name is Missy, not Misty? Does it matter if she got the Oragel or not? Count 10 is the putting Clinton in a dumpster. I believe there's reasonable doubt as to that one. Count 11, making a false statement. Again, this was October 8th. These are repetitive and redundant. This was on October 8th. The prior was, I believe, October 5th. Count 12 is use controlled substances. Again, I'm not really sure how you can admit to using controlled substance. I guess they're saying that you didn't. I don't know. But count 12 to me, I don't understand it. I don't see how it's beyond a reasonable doubt. And I ask for not guilty on that one as well. Count 13 again is the Oragel story yet again. Count 14 is the dumpster story yet again on a different day. Count 15, Misty again on a different day. So a lot of these are repetitive and redundant. So when you're back there, You have to consider the witnesses, their manner and method of testifying, and what they testified to. Why do I say that? Do you really care if she was sleeping with Craig Weston? Does it really matter? Is it germane to whether or not Quentin Simon was killed intentionally or died as a result of his accident? I present to you no. Some of the evidence they presented too, and again, Officer Zerke, I have no doubt she was emotional about it. But again, the only reason to put her up and have her cry was to have her cry. Did she add anything beyond that? No. It was to play on your emotion. And it doesn't matter how much, how often, how long they played on that emotion. It doesn't change the fact that they haven't produced any evidence. They haven't met their burden. They haven't proved that Miss Simon killed her son. Give me 1 second. I'm going to ask you to go back there, ladies and gentlemen. I'm going to ask you to do the hardest thing you've probably ever done in your life, is to set your emotions aside, to view the evidence, and to return a verdict of not guilty. The state has not proved that Miss Simon killed her child. They have speculated wildly, I might add, but they produced no evidence. And I know that that's a hard thing to ask. But I'm going to ask you to do it. Thank you.